If you are targeted by discrimination, you don't have to be a victim. You can fight back. But before you can hope to be successful, you must be able to prove your case. In this video, I'll share the 4 basic things you need to know to prove discrimination. They get increasingly more important, so stay tuned. Proving your case can make the difference between a multi-million-dollar verdict and extended unemployment. Learning some basics about employment discrimination law can help you understand how to prove discrimination occurred. In this video, I'm going to cover a little lingo, what you need to prove, forms of employment discrimination, types of evidence. This is the first episode in a series. So, if you're watching it first, great. If not, I'm glad you found it. Later, I'll talk about how you can skip ahead to only view the topics that are relevant to your situation. This is not legal advice. For that, you need to speak to an attorney about your specific situation. Before I dig into these 4 topics, I want to share a story about how sometimes all you need to succeed is a little knowledge and a little strategy.
I was working as a federal investigator for the Equal Employment Opportunity Commission when a gentleman, I'll call him James, came into my office.
James was laid off after 15 years. His boss was a friend and said he was being laid off due to budget cuts. James was in his early 50s at the time, and his co-workers told him he was replaced soon after by someone 20 years younger. James believed he was fired because of his age, and he wanted to file a charge of discrimination. Knowing his former friend's best defense would be to describe James as a terrible employee, I convinced James to request a letter of recommendation before going further. James's boss, perhaps feeling guilty about his actions, wrote a glowing letter of recommendation. James won his case before it began. If James had asked his former friend for a recommendation after filing a discrimination complaint, he never would have obtained one that was so glowing. James eventually sat down with his old boss and a couple of attorneys, and they quickly reached an appropriate agreement. And now, Alex, I'll take legal lingo for 200. Protected class. Class in legalese means group. A protected class consists of people who share a characteristic that cannot legally be used as the reason for employment discrimination. Protected classes under federal law include race, sex, and religion. In addition to federal laws, laws prohibiting employment discrimination exist in states, cities, and even a few counties. They cover discrimination based on a diverse spectrum of protected classes not covered by federal law, such as marital status, but only in the geographic locations covered by these laws. A protected characteristic which provides the motive for discrimination is termed the basis for the discrimination, like in the title of the Ruth Bader Ginsburg movie. Decision makers are individuals whose decisions can affect an employment relationship. People who make hiring, firing, and salary decisions are decision makers. Managerial decisions that negatively affect an employment situation are adverse actions. Adverse means bad. Terminations, demotions, and poor performance evaluations are all adverse actions. I'll be sharing a little more lingo later, but that's enough to get us started. What you need to prove. Top 4 answers on the board. We asked 100 workers, what are the most common adverse actions? And the answers are not being hired, not being promoted, being disciplined, and being discharged. For each of these, a certain pattern of events must occur for there to be an appearance of discrimination. This is called a prima facie case. Hiring and promotion decisions must include the following before there is an appearance of discrimination. You must apply for an open position for which an employer is seeking applicants. You must be qualified for the position, meaning you have the advertised credentials, or in the absence of advertised requirements, you must possess the skills, training, or abilities to do the job. Lastly, after you are denied the position, the employer must make further attempts to fill the position or fill the position with a person without your protected characteristic. There are some notable exceptions. If you're discouraged from applying for a position because of discriminatory practices or advertising, you can still be the victim of discrimination. For a promotion, a formal application is not required if the employer knew of your general interest in a position, but you were unaware of the vacancy. Normally, your hiring or promotion case would fall apart if the position is not filled or is filled by a person with the same protected characteristic as you. But it is illegal for an employer to intentionally refuse to fill a position to avoid hiring or promoting you because of your protected status. A disciplinary action against or discharge of an individual in a protected class appears discriminatory when an employee not in the protected class, but with equal or worse performance, is not similarly disciplined or discharged. Or, in the case of a discharge, the employee in the protected class is replaced by an employee not in the protected class. If you are discharged, you must prove that you were performing at or above the legitimate expectations of your employer at the time of your discharge. Often, individuals suffering discrimination are forced to quit. Being forced to resign because of discrimination is termed constructive discharge. Proving a constructive discharge case is more difficult. You have to prove that the discrimination was sufficiently pervasive that a reasonable person in the same situation would have resigned. You may be able to establish a compelling constructive discharge case if you resigned after experiencing 3 or 4 significant discriminatory acts, like being denied a promotion, instructed to train a future supervisor, demoted with a big pay cut, told you will never be promoted or receive raises, told you would be terminated or told to find another job, received a poor evaluation, experienced threats to your personal safety. In some parts of the country, federal courts also require you prove that your employer was trying to force you to resign, which is extremely difficult. Experiencing pervasive harassment, particularly sexual harassment, is the most convincing reason for a constructive discharge. If you make a formal complaint about discrimination and demonstrate the appearance of discrimination, established a prima facie case, your employer must offer a non-discriminatory reason for the adverse action. You can expect your employer to accuse you of poor performance, unethical behavior, or worse. You would then need to prove that your employer is lying and that discrimination was the true motivation for the adverse action. If you are finding this information helpful, click that subscribe button below. There's a lot more coming in this series about employment discrimination that I think you'll find very useful. Employment discrimination usually happens in one of 3 ways. The most common form of discrimination is disparate treatment. Disparate means different. Disparate treatment is treating an employee or applicant differently because of prejudice against their protected class. Inherent in a disparate treatment case is a discriminatory motive, but you don't need to prove that the decision maker was acting deliberately or maliciously. Let me give you some examples. A newly hired carpentry supervisor terminates an African American carpenter for poor performance. Other non-African American carpenters with worse performance are not terminated. Or An events company hires two recent college graduates, a male and a female, as entry-level event planners. Neither has any prior related work experience. The company offers the newly hired male $2,000 more per year than the female. In these examples, a discriminatory motive can be inferred based on the disparate treatment of the employees. Reasonable accommodation. Anti-discrimination laws grant additional rights to employees based on their religion, pregnant employees, and employees with disabilities. When needed, employers must make allowances for these employees and applicants. If you need a reasonable accommodation to perform your job, your employer must provide it. A qualified applicant also has a right to a reasonable accommodation to participate in the application process. An employer's responsibility to provide these reasonable accommodations differs depending on whether the need for accommodation stems from a disability, pregnancy, or a religious belief. We'll discuss these in depth later. The third form of discrimination is disparate impact. Disparate, meaning different, impact is a neutral policy or practice with a greater negative impact on a protected class. This type of discrimination is much less common. The emphasis in this type of discrimination is on the effects of the policy, not the motive for creating it. The effect of a policy excluding a significant portion of a protected class could be entirely unintentional. Evidence can be verbal or written. A statement by an individual associated with a discrimination case is witness testimony. Written evidence comes in various forms, including performance evaluations, memos, job descriptions, collective bargaining agreements, and emails. A journal you keep detailing the discrimination you are experiencing is also written evidence. Ideally, you would do this in an email account that you created specifically for this purpose. In a future video, I'll discuss evidence in greater detail, including providing suggestions for identifying the evidence appropriate to your case and including ideas for how to acquire this information. For now, just know there are three categories of evidence. The first, and most common, is comparative evidence. Most disparate treatment cases rely heavily on comparative evidence. Comparative evidence reveals unjust treatment of protected individuals by comparing similarly situated employees or applicants. Employees are similarly situated when their relevant circumstances or relevant backgrounds are equivalent. The rationale behind comparative evidence is that two or more employees with equal backgrounds doing the same thing should receive equal treatment. If the only difference between two employees is, for example, one is white and the other Mexican American, and they're treated differently, the apparent cause of their differing treatment is their national origin. I'll talk in detail about the factors to evaluate whether someone is similarly situated to you another time. Direct evidence is the strongest evidence that exists. Not surprisingly, it's also the hardest to find. Direct evidence exposes a decision-maker's bias against a protected class. A decision-maker shows prejudice through making disparaging remarks, promoting stereotypes, and committing macroaggressions. The best direct evidence is a smoking gun, which establishes a discriminatory motive for taking an adverse action against a particular employee. Direct evidence also includes evidence that an employer was aware of the need for a reasonable accommodation and failed to act. Statistical evidence examines the larger picture to see if a pattern and practice of discrimination exists. Statistical evidence may sound intimidating, but what you need to know is fairly straightforward. It's compiled by comparing the proportion of protected class members who experienced an adverse action with those who did not. So, for example, let's say a company lays off 100 employees, and 50 of those employees are over 40 years old. That's 50%. And let's say before the layoff, 30% of the company's employees were over 40 years old. The 50% of older workers laid off is a much higher proportion than the 30% we would expect. When a protected class experiences an adverse action with greater frequency than expected, that can be statistical evidence. Different types of adverse actions naturally lend themselves to particular types of evidence. Hiring cases often depend on good statistical evidence. For harassment and reasonable accommodation cases, direct evidence is crucial. A promotion or termination case might rely on all three types. For any type of case, the more evidence and more types of evidence, the stronger the case. In the next videos, I will focus on how workplace discrimination affects different protected classes. Only watch those for your protected class or classes, like age discrimination or disability discrimination. If you're experiencing harassment for any basis, you also want to watch the part of the sex discrimination video about hostile work environment. We'll all meet back together at the video on retaliation, which everyone should watch. This discusses protections for people who complain about discrimination. I have been doing a lot of talking, and now I want to hear from you. What areas interest you? What topics would you like me to cover? Take a moment and enter your ideas below. Thanks for tuning in.